I just filed 23-6704FH and defendant's present with counsel. We're here for a probation violation hearing. Ms. Elliott, do you know how Ms. Good wishes to proceed?
Yes, Your Honor. Ms. Good intends to enter a guilty plea.
Ms. Good, would you please stand and as best you can raise your right hand for me? You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, you can be seated. All right. All right, so all the paperwork does still have to say Zarzini, which was the file that she came in on, but I'm gonna refer to her as Miss Good. She had a divorce while since entered on probation, so the paperwork will still have to say Zarzini because of some tracking numbers we have to have with the state, but I'll refer to you as Miss Good.
Thank you.
All right, so Ms. Good, do you understand you have the right to have a hearing on these allegations where they would need to be proven by a preponderance of evidence?
Yes.
You understand you have the right to the assistance of your lawyer at that hearing?
Yes.
Has anybody promised you anything in exchange for pleading guilty to violating probation?
No.
Has anybody threatened you to make you do so?
No.
Is it your own free choice to do so?
Yes.
You are on probation to this court for operating while intoxicated, third offense. That has a maximum penalty of 5 years in prison. Do you understand that I could revoke your probation and sentence you on the underlying offense to that maximum?
Yes.
Knowing all these things, how do you wish to plead to the allegation that you violated probation?
Guilty.
So are you on probation to this court for OWI third?
Yes.
And you were ordered to complete the recovery court program?
Yes.
And on or about August 7th, in violation of that program and your probation, did you fail to submit a sample for drug testing?
Yes.
On or about August 7th, in violation of your probation in that program, did you fail to attend a counseling appointment?
Yes.
On or about the next day, August 8th, again in violation of your probation in the program, did you fail to report to your probation agent or case manager?
Yes.
On or about August 12th, did you again fail to attend a counseling appointment?
Yes.
And on or about August 12th, did you again fail to report to your probation agent or case manager?
Yes.
On or about August 13th, did you fail to appear for a recovery court hearing?
Yes.
And then did you thereby fail to, or did you fail to abide by the terms and conditions of recovery court program by failing to complete required community service hours for the first full week of August?
Yes.
And also thereby failing to successfully complete the recovery court program?
Yes.
Ms. Elliott, are you satisfied with that factual basis?
I am, Your Honor.
Ms. Goodrich?
Yes.
Ms. Elliott, are you aware of any promises, threats, or inducements at all?
I'm not.
Ms. Goodrich?
No, Your Honor.
All right, Ms. Good, I find that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe that you have violated the terms and conditions of your probation. So I do accept that plea. These are technical violations. They are more than 4. So we're going to schedule this for a probation violation sentencing hearing, and I'll have the Department of Corrections prepare a probation violation report. And Agent Fagan, could we have that done by the September 30 date?
Yes.
We'll schedule this then for September 30 at 11:10 a.m. Anything further from the people?
No, Your Honor.
Anything further from the defense?
No, Your Honor.
Okay, we'll see you then, Kayla.
Thanks.
All right, and then this is Mr. Page. Okay, next we've got People with Joshua Page. 25-7042. And we are here for a docket call. Ms. Elliott, do you know how we're proceeding today, what the status is?
Yes, Your Honor. We have a plea agreement whereby Mr. Page is agreeing to plead guilty to count 1, OWI 3rd, and habitual offender 2nd offense. In return, the prosecution is going to dismiss count 4 and the habitual 4th enhancement. There's a sentencing agreement that any incarceration ordered shall be within the Michigan sentencing guidelines. There's OWI reimbursement of $200, and Mr. Page does wish to avail himself to that agreement.
Okay, and do you have a advice of rights form you've signed with them then? Can we
I
get
do
that for you?
not.
Yeah. Yeah, on these, especially when there's a sentence agreement, but even on all of them, the recent court rule change makes it so that I should have those as well.
Your Honor, we'll be bringing up the amended.
Okay.
at a later time.
Okay, you consent to the later filing of the amended information with the habitual 2nd?
Yes, Your Honor.
Okay, I'll give you a minute to go over that. Off, and I wanted to refresh my recollection of what had happened in the previous case, and then talk with counsel and chambers about that. And based upon my review of that history, I advised them, Mr. Page, that I would not be accepting any plea bargain that included a sentence cap or sentence bargain in this case. So we'll not proceed with the plea taking today, and I'll schedule this for further docket call on September 9th at 10:20. Anything further from the people,
No, Your Honor, thank you.
from the defense?
No, Your Honor. Thank you.
Okay, we'll see you then, Mr. Page. We're back on the record in 53rd Circuit Court, and up next we've got People versus Walter West, file 25-7045FH. Counsel, you want to state your appearances for the record, please?
Anthony Julian on behalf of People.
Liz Elliott on behalf of Walter West, who joins us via Zoom.
Okay, and we're scheduled for a docket call today. Do you know how we're proceeding, counsel?
Your Honor, we have a plea agreement. The prosecution has agreed to allow Mr. West to plead guilty to an amended count 2 of attempt embezzlement of an agent or trustee, 1,000 or more, but less than 20,000. And in return, the prosecution would dismiss count 1, the original count 2, count 3, and the habitual offender enhancement. And restitution is to be determined at a restitution hearing.
Okay, do you have a written plea agreement?
I do, Your Honor.
And you agree to the filing of the amended information?
I do.
All right, I received that. That's accepted for filing. Mr. West, would you please raise your right hand for me, sir?
Yes, sir.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You can put your hand down. Are you Walter William West III?
Yes, sir.
Mr. West, a guilty plea hearing is an important event. It includes the waiver of constitutional and other rights that you have. So I want you to listen carefully. If you have any questions, ask them. If you need time to talk to your attorney, you just let me know. I have to advise you the maximum penalty for the attempted embezzlement over $1,000 is a felony, punishable by not more than 5 years in prison or not more than 1 year in jail. Oh, with probation, or is that like I don't understand what that statutory maximum, what that means. It's a felony punishable by a maximum of 5 years in prison. All right, do you understand that maximum penalty?
Yes, sir.
Yeah, I don't either. Okay, this says not more than 5 years in prison or not more than 1 year in jail. I'm not sure what that means.
In looking at the attempt statute under 750-92, it says not more than 1 year in jail or not more than 5 years in prison.
First up, Miss Good formerly, Zarzini's back for a probation violation. She admits one by one. missing drug tests, skipping counseling, failing to report to probation, and even not showing up for recovery court. The judge calls them technical violations, but more than 4 in just 1 week. For someone already on probation for a third OWI felony, that's a serious red flag. Her fate now rests on a violation sentencing hearing, where she could face up to 5 years in prison. Should multiple technical slip-ups be treated as harshly as new crimes?
So I don't know what that means either.
I guess I'm a little confused.
Or in the county jail, if not, okay, yeah. So it's just meaning that we don't have to send, okay, I'm looking at that statute. All right, so Mr. West, what that just means is I don't have to send you to prison. If I don't send you to prison, the maximum is a year in the county jail. If I send you to prison, the maximum is 5 years. You understand that?
Yes, sir.
All right, are you on probation or parole?
Yes, sir. I was on probation.
At the time of this offense, you were on probation?
So like the events happened, I think before. It's just a little confusing. Before I was on probation, I've contacted them. They just said wait until the outcome. So.
Okay, so your probation agent knows about this offense?
Yes.
Okay, so I just want to make sure you understand that that could negatively affect your probation status, and it sounds like you do know that.
Yes.
Were you on bond for any other cases at the time of this offense?
No.
If you enter a plea, you won't have a trial of any kind, and you'll be giving up the rights that you would have had at trial. Do you understand that?
Yes, sir.
I want to remind you of some of those rights. You would have the right to be tried by a jury, and at that trial to be presumed innocent unless and until the prosecutor proved your guilt beyond a reasonable doubt. You'd have the right to have the witnesses against you appear and to question them. You'd have the right to present witnesses in your own defense and have me order them to show up. You'd have the right to testify in your own defense at trial or to remain silent and not have your silence used against you in any way. Do you understand those rights?
Yes, Your Honor.
Do you wish to give up those rights and enter a plea under this agreement today?
Yes, Your Honor.
Okay, if I accept your plea, you give up any claim that it was caused by any promises or any threats that aren't placed on the record today. Do you understand that?
Yes, Your Honor.
Also, when you plead guilty, you lose the right to appeal. If you wanted to appeal, you'd have to seek permission by filing an application. The types of issues you could raise on an appeal by application are very limited, much more limited than if you were convicted after trial. Do you understand that?
Yes, Your Honor.
All right, the plea agreement provides in exchange for your plea to the attempted embezzlement over 1,000, the original charges, remaining charges, and the habitual will be dismissed. Do you understand the terms of that agreement?
Yes, sir.
Has anybody promised you anything other than that?
No, Your Honor.
Has anybody threatened you to make you enter the plea?
No, Your Honor.
Is it your own free choice to do so?
Yes, Your Honor.
Knowing all this, how do you wish to plead to the charge of attempted embezzlement over $1,000 but less than $20,000?
Guilty, Your Honor.
Ms. Elliott, would you assist with factual basis, please?
Yes. Your name is Walter William West III.
Yes, ma'am.
And were you in Beau Grand Township, which is in Sheboygan County, on May 21st of 2024?
Yes, ma'am.
Okay. And Mr. West, were you an employee of Roberts Landing Campground?
Yes, ma'am.
And that's owned by the Legio family?
Yeah.
I'm sorry, I missed that.
Yes, ma'am.
Okay. And in the course of your employment at the campground, did you accept cash payment for customers at the campground?
Yes, ma'am.
And is it true that you kept some of that cash that was turned over to you?
Now we move to Walter West, caught embezzling thousands from a campground he worked at. Instead of facing multiple felony counts and a habitual offender enhancement, he pleads down to attempted embezzlement over $1,000. That reduces his max exposure to 5 years in prison or just 1 year in county jail. He openly admits pocketing more than $1,000 in campground cash. A restitution hearing will determine how much he must repay. But the real question is, should theft from a family-owned business land someone in prison? Or is probation and restitution enough punishment?
Over to you, and the amount is more than $1,000, but less than $20,000?
Yes, ma'am.
Your Honor, I believe that establishes a factual basis for the plea.
Okay, do you concur, Mr. Juliet?
Yes,
Ms. Elliott, are you aware of any other promises, threats, or inducements?
No.
Mr. Juliet?
I'm not.
Ms. Elliott, in your judgment, has the court fully complied with the requirements of MCR 6.302?
Yes, Your Honor.
Mr. Juliet?
Yes,
All right, Mr. West, I find that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe you're guilty of that offense. So I hereby accept your plea. Do counsel anticipate a contested restitution hearing in this matter?
at this point, I believe we do.
Okay. All right, not more than an hour in length of time, you think?
That should be enough. Yes.
What we'll do then is we're going to schedule this for sentencing on October 7th at 9 a.m. And that way I'll reserve the 9 o'clock hour for that sentencing in case there's a restitution hearing. And Mr. West, you'll have to cooperate with a pre-sentence investigation and report. So you'll need to contact the probation department today, tell them you entered a plea so that you can schedule an interview. You have to cooperate with that process. Mr. Juliet, any objection to continuation of bond?
No objection.
Bond will be continued and the sentencing will be October 7th, 9 a.m. It'll be in person here in the courtroom for you, Mr. West, okay? Do you have any
Sure.
questions for me, sir?
No, sir.
Okay, we'll see you then.